Thank you for joining us tonight for our very first hybrid event. My name is Barry Erickson and I'm Community Engagement Coordinator at Wheaton Public Library. And tonight we are proud to bring you the Bad Girls of Justice with Tauya Forst. Tauya is a professor of justice studies at College of DuPage, who was recently appointed as the co-chair of the Equity, Diversity, and Inclusion Human Resources Subcommittee. She holds a BA from Bradley University, an MS from Grand Canyon University, a JD from Northern Illinois University, and graduate certificates in both online instruction and restorative practices. Professor Forst's legal experience shapes her passions of intermingling law, education, and restorative practices. Additionally, she co-led COD's first silent demonstration regarding racial and social justice entitled 846, Not Just a Moment, but a Movement. This was on campus for faculty, staff, and the COD community. As an avid champion of restorative practices, Professor Forst envisions moving the racial and social justice conversation forward both nationally and internationally. Currently, restorative practices lead her teaching and research agenda. This practice is critical in her classroom instruction and has been applied through assessment, identification, and authorship of a manual to train youth to participate in a juvenile peer jury as an alternative to criminal convictions. Tauya is an active member of the DuPage County Bar Association and a commissioner for the Glen Ellen Community Relations Commission. Finally, she co-wrote with attorney Robert Forst a justice studies textbook entitled Constitutional Law Comes Alive, an Innovative Approach. So let's welcome Professor Forst. Thank you so much for being here.
Hear ye, hear ye. The Honorable Court of the Bad Women of Justice is in session. Yay! Yes. I am super excited to be here. This is one of my passions. And the more you learn about the bad women of justice, the more you want to learn. So I do not stand before you saying that I have every expertise, but I live, breathe, bathe in this stuff. It's good stuff, right? So before we get started, I thought I would sort of bring you on the path of how we even get to the Supreme Court, if you wouldn't mind. But I thought I'd kind of take you through some things, and you'll see me referring to notes because at some points I'll actually read what's included. I'm not used to staying to the mic, so here we go. It's gonna have to kind of roll with me. What's included in the actual cases. So if you see me referring to notes, that's what's happening. Okay, so I am Tauya Forst. I'm not sure who she was speaking about, but I do love the law and I love the intersection of the law. So here we go. Or no. Can you guys see that? All right. So in our time together, we'll go through the background of the Supreme Court of the United States. Sometimes you'll hear me refer to it as SCOTUS, which is the official name. We'll go through the composition of the court, timeline of the women of SCOTUS, impact of the women of SCOTUS, and the future. Are we okay? Okay. All right. So, yeah. As we go through the background of the Supreme Court, I really just wanted to take you through how justices come to be on the court and how cases actually flow through the court. I will ask some questions as we go along, but those general questions that you may have, if you would hold those until the end, I would appreciate it. Okay, so let's just talk a little bit about the authority of the court. So the authority is really nestled in Article 3 of the United States Constitution, and specifically, it allows and connects with the Judiciary Act of 1789. In order for justices to come, they're nominated by the president and confirmed by Senate. And that's found in actually Article 2. Article 2, Section 2, Clause 2. Presidents shall nominate and by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court. Okay, so here we go. Most people believe that the actual Constitution actually states that it should be 9 justices, but this isn't really true. There's nothing in the Constitution that sets the number. And in fact, since the Constitution began, our first court was seated 1790, we've had a varied sort of approach to this. We've had as few as 6 justices and as many as 10 justices. But at any rate, we settled on this number of 9 in 1869, and that included Chief Justice and 8 Associate Justices. So our very own justice that is seated now, our Chief Justice is John Roberts. He is the 17th Chief Justice. I think that's kind of interesting because from 1790 to now, so think about all of the span of years we've had. There are 103 associate justices, and justices typically are on the bench about an average of 16 years. But our bad girls of justice will defy that. So just hold that in your mind for a second, okay? All right. So I wanted to talk through sort of the process of how one becomes a justice. And I'm going to keep this handy dandy sheet to make sure we don't get any misinformation out there. So the president actually consults Senate sort of on a basis before he makes the nomination. And I think it's so exciting that we're seeing that right now, right? We can walk through this process. We've probably seen more justices kind of tramps through the court in the past few years than in a long time. And before announcing that nomination, obviously he's trying to determine whether or not there will be sufficient support, right, for that nomination, for the nominee. Once the president nominates, then that nomination actually goes to the Judiciary Committee. What's really interesting about the Judiciary Committee is that they actually have their own hearing. Once they're doing their hearing, they will come away with a vote. And after that vote, they will either say that they want to confirm this nomination, reject the nomination, or give no recommendation. Now, hold that no recommendation. We don't have enough time to go into that, but that has happened on the court, okay? And there's even been a time where the vote was not called. So we don't typically like those, right? We want to make sure everyone who's nominated actually gets this opportunity. After that particular vote goes forward and that recommendation, then it's turned over to the complete Senate. And the full Senate would then take up this particular nomination, and they can actually debate ad nauseum about this particular person. They can ask questions, they can bring in witnesses, they can do all of these things. Typically, they take about a month to look at records before they do that. But it's really interesting that you'll see sometimes the time is longer and sometimes it's shorter. So I think we've been able to see both. In 2017, the whole composition of how this thing works turned around. So before 2017, it was about a 3/5 vote for individuals to stop the debate. After 2017, we turned it around and we start to use the nuclear option. Okay, so how does that affect you, and does it even mean anything? I think it does. So here's the flow of cases. And I tried to go kind of step by step because you can get lost in this, I think. So in general, there's about 7,000 to 10,000 requests that are made to the Supreme Court of the United States. Out of those 7,000 to 10,000 requests, some of those are automatically appealed, right? You would imagine that there are some cases that you would want the final arbiter, which is the Supreme Court of the United States, to hear. What kinds of cases do you think that would be? What do you guys think? What kinds of cases would you want the final arbiter to hear? Anyone? Laws of the land? Anything else? As an automatic appeal, right? I'm saying, what is it that we would definitely want them to see before we say that this is the final decision? What do you think? And that is actually what typically comes into the 7 to 10,000, but those are not automatic. So when you think about the criminal law, does that help? What is it? What kind of sentence would you want them to review? Death eligibility, right? So we would not want someone to be put to death, I would hope, if there's a chance that there are some other things that are out there. And so those are the kind of cases that typically come up right away. Now, when a request is made, they use a writ of certiorari. And the writ of certiorari is a simple request for the lower court asking the Supreme Court of the United States to review the case. In reviewing the case, yes, sir. That is exactly what we said. So tell our chat community, they are over this. They are all over this. They're in the room. They know exactly what's happening. Thank you for that. But the writ of certiorari is a request from the lower court that the Supreme Court actually review the case. Now, out of the 7 to 10,000 cases, then it goes through a process which we call the rule of 4. So 4 of the 9 justices must agree to hear the case. Everybody with me so far? So we're going from 7,000 to 10,000. How many do you think get to this point where the justices actually say, yep, we want to hear this case? You think nothing? Oh, not many. Great answer. Can we put a number on not many? Online communities, chime right in. What do you have, Barry? I love 100. That must be one of my students. They cheated. So it's about 100 to 150, right? So you think about it. This is huge, right? Coming from 7 to 10,000 to 100 to 150. And then those 100 to 150 may or may not be set for oral arguments. Oral arguments are actually 30 minutes in length for either side to present their case. Those go on for twice a day. And the actual court meets from October, the first Monday in October, to the next Monday in October of the following year. They actually only hear cases, though, from October to April. When I tell my students this, they say that the court is lazy, right? That's a laugh, right? Because can you imagine? They not only have to hear each case, they have to read everything that's below and then create their own opinions and have conferences. They're not lazy. Yes, sir. So this is the thing. In my mind's eye, I want to say it's a dual job. And I'm going to stick with that answer. You know? That's going to be what I'm going to stick with. Because here's the thing, ultimately, as a lawyer, and every judge is a lawyer, we know that whatever we place our names on actually does not go to anyone else. So even if the clerk reads it, someone else, i.e. the person signing, needs to reread it. Does that make sense? So even if the work is done by someone who's underneath them, they still are putting their own signature on that opinion. So it's very dangerous. If you ever know a lawyer, one thing that we always say, we have our assistants review things, but we read it because actually that can come back on us. Does that make sense? Okay, but that's a great question. So they go in conference, and after the conference, they discuss the case and take a vote. How many justices does it take for the case to actually be one that is in favor of the party bringing the claim? 5, right? So we want at least 5. We can have a 5-4. That happens a lot. But once that happens, then we have what's called a majority. And the majority who has seniority typically will write that opinion. Any questions on this so far? Yes, ma'am. Mhm. Yeah. That's a really great question. And the question for our online audience was, is 30 minutes it for how much they have to present their cases? So it goes like this. This is what they're actually allotted. You can say, I will use my time. I'll yield my time to later, but questions are coming as they're presenting, correct? So the time isn't flowing exact. It looks like this would just be great. 2 30-minute hearings, right, for a day, but that actually doesn't include any interaction from the bench. So when we're talking about the bench, the time can be prolonged. The other thing that I think I should say is that in typical cases where the United States is a party, the Solicitor General is actually presenting the case on their behalf. Does that make sense? However, sometimes the Solicitor General will come in and give their opinion even when the United States is not a party. So that would actually increase the time too. But also they're reviewing the record. So we can't forget that. They're reviewing all of the documents that come with the case. So it's not just the oral arguments that they're making their decisions on. That's a great question. Okay, composition of the Supreme Court of the United States. Now, I'm going to ask you guys to kind of get involved, and I'll repeat what you say. Online audience, you can do this as well. How many total justices do you think we have? How many total justices? Since 1790, you are very smart. Yes, the entire history of the court. How many do you think? 100 and something. That's a great number. 180, 170. Any other numbers? 117 on 135. I hope that wasn't one of my students. 115 total justices. Now you have to think about this because some justices were chief justices. So that number might seem or appear to be larger, but that's a large number, 115, right? We're going back to 1790. How many of the 115 do you believe are men? Oh my goodness. Okay, wait 1 second. Let me hear it. 110, 111, 112. Online, any Barry? 111. Oh, you guys are so smart. Actually, total number of men on the bench thus far is 110. I bet you can figure out that last number. Yeah, that's why we're here. And that's why we're calling them the bad women of justice. 5. So I love to talk about this number for a minute, because if you think about it, you might say, well, it's 10%, right? Not even 10%. How about 5%? Barely, right? Barely 5%. So I think what we have to do is really think about that. Now, if you look at it, and we don't have time to go there, Senate.gov and US Supreme Court.gov, you will see each and every president that the justices have went through. And I think it'll kind of surprise you how many presidents it took to get to these 5. Okay, so that's what we'll discuss next. First justice took the bench 1790. Everybody with me so far? All right. When do you think the first woman took the bench? 1984, 1963. 80? 80? 80 online too, Barry? 1980, all right. First woman actually was confirmed and took the bench 81. She took her oath, right? She was nominated in 80 and she took the bench in 81. And you guys are an easy audience. I think you're gonna help me teach this. This is what I really like to focus on. All 5 of these women came from 81 to 2020. For our people online, and most people, you can remember what you were doing in 1981, whether you were just born or you were doing something else. But this is not a long time ago. So I want us to understand that the influence and the impact of women on the Supreme Court of the United States is new. That is what I would say. And it's interesting that Barry said this is their first hybrid meeting, because what you see with the justices is they are first in so many ways. I think we like to focus on the things that are obvious, but they're first in a lot of different ways that I hope will surprise you. And if you're like me, enthuse you. Okay, so timeline of the women of the court. You're gonna help me kind of talk through. Online, you can type in the chat. We're going from left to right. Who do we think is the first justice? Sandra Day O'Connor. Who appointed her? Who nominated her? Ah, okay. And we already talked about the year, and she actually took office. Who's our next one? RBG. I like to call it a notorious RBG, and I'll tell you later why I like to do that. Who nominated her? Clinton. And what year did she take the bench? Any feedback online? What year did she take the bench? I love it. I love it. So now we know it's at least 10 years later from our first one, right? Would you be surprised to know? Right? So 12 years, and now we have our second woman. How about the third woman? Oh, wow. Who nominated her? President Obama. And now we're starting to get into the 2000s. You see what I'm saying about this 2020, 81 to 21? That time frame is really short. Let's look at our next one. How about here? Elena Kagan. You guys are good at this. Who nominated her? Ah, what year? Just like a teacher, I always want to stump you. Never want you to. What do we think? She took her oath 2010, right? So she's fairly new. And last but not least, yes, very much so. And she was nominated by, there we go, 2020. Can you believe that? So what I think is really interesting about this whole concept, and we'll go through, and I always like to do this for young women, older women, middle-aged women, whatever. We know that we have another probable woman who may take the bench, but I'm wondering if you can see yourself on the bench. Really, this is the purpose for this presentation. You, someone you love, someone you know, to help change the dynamic and the impact of the bench. Does that make sense? You'll start to see that these women really balanced a lot to get here. And I hope that you recognize, but what we'll see next when the slide comes back up is quotations from each of these women. And I think some of the quotations you might know and you might be aware of, but some of them might actually surprise you, that individuals who took the bench would then take a different stance. That's the thing I think, right? How long does one get to remain on the Supreme Court of the United States? Life. So that means that just the way that you were hired, if you will, may not be the way that you evolve as you're on the bench. Does that make sense? Okay, we ready? All righty. Need to go from the current. All right, we got it. Yeah. There we go. All right. So impact of the women of the Supreme Court of the United States. What do we learn from these women? What can we learn? I think this is sort of a get down dirty version of what you can learn. It includes not only now you've told me who actually nominated them, but who they replaced. And I think this is really interesting as we start to talk about what they do in their careers and how they come to get on the bench. One thing that I always say about the bench is not diverse, not because of gender, not because of race, but a lot of times because of geographic areas, a lot of times because of backgrounds and where people are elevated onto the bench. And then even more so what their responsibilities and what their lifelong sort of imaginations and interactions with the law has been, okay? So it's important that the bench actually reflects in some way the people that they serve. And make no mistake about it, justices are servants. Everyone in the three branches are servants, whether they know it or not. It's quiet in here. You guys don't like the word servants? Attorneys are servants. Police officers are servants. Teachers are servants. Should I go on? Servants mean that you no longer bring your opinion to the bench, right? You take the facts, you take the law, and you look at it from the perspective of what the precedent, I think is what you guys were talking about earlier, is. Okay, so do you see any patterns with this slide? Does anything kind of stick out for you? So the vote is when they actually take up the full vote within the Senate and whether or not they're confirmed. So what do you think about that column? That's a really interesting one. What do you see? Do you see anything changing or different? As it went on, right? Can you imagine in this day and age, a 99-0 unanimous vote? Well, we had one in 81. That wasn't long ago, right? And then we move, okay, RBG, 96-3. But look at it. We start to really hit party lines. And I think that we'll see that even the justices agree in a lot of ways that this is not good for the country. So I think what has happened is our Chief Justice, who actually, for all intents and purposes, did lean one way, tried to kind of counterbalance some of this, right? So you see him doing something different, which we're appreciative of. Anything else stick out to you? Any other similarities or differences? So when we get to Justice Kagan, it looks like she is not a bad woman of justice. But I should tell you, I am very impressed with her resume. But you are exactly right. Would it surprise you to know that 40 other justices never had any judicial experience before they hit the bench? It would shock you. 40, not 2 or 3, 40. So this is not uncommon, but that's a great, I think, pick. Anything else? There you go. You're looking at my column. Yes. So here we go. Remember, I said actually to get the record is really about a month. So it's possible. I'm not sure if we started to swing this other way, or we like to believe that we're actually vetting the candidate in a way that is more bipartisan when we take longer. I'm hoping that's what's happening, but you're exactly correct when you start to look at the time. And of course, we don't know about just Judge Katanji Brown Jackson, what her process will look like, but I will be curious to see how long that will take, regardless of the outcome. It'll be interesting. So you guys hit everything. The only thing I would say is Clerk 4, right? So Clerk 4 is a really interesting one. Did you have something to add, Barry? Okay, he said that it's interesting that Justice Sandra Day O'Connor and Justice Amy Coney Barrett went through the system within 1 month time frame, give or take. that that's interesting. So at a point when clearly everyone was in agreement, that's that 99-0, and we are clearly divided, we have a short time frame. So I agree. I think that's a really interesting point. Thank you for letting me know. The other thing I would just talk about is this whole clerkship. And I'll get into that more as we talk about each individual justice. But I wanted to show you that for the most part, you see Elena Kagan, she's under Justice Thurgood Marshall. You see Katanji Brown Jackson, she clerked for Justice Breyer. The other judges are actual district court or appellate court judges. But this is another sort of similarity that you see with individuals on the bench, that they would have to have clerked for someone. So I want you to kind of think about this when I'm talking about the lack of diversity. If there are only 9 justices and you can only clerk for those 9 justices to prepare you to get on the bench, how does that work? Our numbers are dwindling. Again, we can look at race and gender and those things, but we have to sort of think about these other areas that we need to diversify. But I think there is some interesting information coming forth. Okay, so our very first justice was asked by Wolf Blitzer about Bush v. Gore. How many people know about Bush v. Gore? Yep, we talked about it so much when it came out. I'm sure you don't want to hear it now. But she had some second thoughts later. 10 years after this particular case, she said, he asked her if the right man was selected. She said, well, the man who got the most votes, that's what it comes down to at the end of the day. 3 years later, she said, I think this was the beginning of the downturn and the demise of the court being sort of this entity that is not like the other entities, right? And now being seen in a way that's very partisan. Gee, I'm glad you asked that. Yeah, so you'll see the quote first, just to kind of get you warmed up. But Justice O'Connor was on for this amount of time. She was actually born on a ranch. And when she was born on the ranch, she really had limited abilities for schooling. So her parents sent her to live with her grandparents. And she finished high school 2 years early, started Stanford at 16. She's a bad woman of justice. Listen to me carefully. Went on to finish Stanford Law. And then there is a list of things that she did. I should tell you, she was head of her class. She was actually number 3. Her fun fact is that she actually shared that particular seat with another justice. And I want to make sure my brain is going out. But she shared that particular seat with her classmate, Justice Rehnquist. Here's the thing. If you're number 3 in your law school class, how do you think your job search will go? No one would hire her. Not only would no one hire her, but they wanted her to work as a legal secretary after she was number 3 in her class. So what do you think she did? No, she said, absolutely not. What I will do is I will work for the county for free. And once you see that I am indispensable to you, you will hire me as the county attorney. 1953, she becomes the county attorney. She actually then goes to Germany. She practices a little bit. She comes back. And what I don't think most people know about Justice Sandra Day O'Connor is that she's actually the first woman to head a political party in any state. This gentleman is saying yes, happens to be my husband. I know he knows that. But most people don't know that she actually had a political career before she went onto the bench. And so she was the first one in her state to do that. She goes on to become a justice on the Arizona state. I'm sorry, she became an Arizona state senator. Then she became the first to lead the party. She went on to the Arizona Supreme Court. And then she penned that particular quote. And I want to read for you another quote that she wrote that I think is really interesting. Okay, so Justice Connor in Mississippi University Mississippi University for Women versus Hogan. This case actually involved gender discrimination. And the reason why I bring it up is because she doesn't necessarily get this kind of credit. It does go to RBG, but I wanted Justice O'Connor to get this tonight. So it was not the kind of discrimination case you would think. So it was a case where a man sued for being denied admission to a traditionally all-female nursing school. But let me tell you about this bad woman of justice. She recognized that whether it was for women or men, right, discrimination, if you hit it at the courts, would extend and have a long arm. So she said that the court ruled that the school must admit qualified men. That's a little hint. And O'Connor also reasoned that not allowing men into the school perpetuated the limiting stereotype that nursing was a woman's job. You think she was setting something up? She also confirmed the case and reaffirmed Roe v. Wade in Planned Parenthood versus Casey, despite the push to overturn Roe v. Wade. I don't think she gets that credit too. So she was the swing vote in that decision. So I think that's really important. You guys with me so far? All right. Here's my next quote. This bad woman of justice, she actually is pretty well known. And you'll hear me talk a little bit more about why and how she affected the court. But she goes through some things that I think everyone should know about. So her quote is, Virginia maintains that methodological differences are justified by the important differences between men and women in learning and developmental needs, but generalizations about the way women are. Estimates of what is appropriate for most women no longer justify denying opportunity to women whose talent and capacity place them outside the average description. What I love about this quote is it almost directly connects to Justice O'Connor's quote. If you think about it, she laid the foundation with men so that this could start to unfold for women. And I'm pretty sure that's what they wanted to do. So who are we speaking of? The notorious RBG. So the reason why she's called the notorious RBG, does anyone know? And the crowd goes silent. Oh, so you do know. All right, to my online community, this is your moment to shine. Notorious RBG was in an interview and someone told her that she's a champion for everyone. There is a rapper whose name is the Notorious B.I.G. and they hail from the same area. So then she became known as the Notorious RBG. But here's her response, which I think is priceless. I am proud to wear the same title. Right? That's priceless. So here we have, she then becomes sort of this pop culture face of the Supreme Court. And men, women, boys, girls, everyone now wants to hear about what's going on the court because she's connected it up to rap. She's ingenious. I should tell you though, her background, right? She was born in Brooklyn. She graduated top of her class in Cornell. And she actually then went on to Harvard Law School. Is anyone gonna correct me? No? It says Columbia, right? So what happened was RBG's husband gets sick with cancer. They're both at Harvard. She has to keep up with his work and she still maintains a top of the class presence until he decides he needed to leave. So he goes to Columbia in that area. She transfers out there against every professor's, right, their advice. and she still comes out on top. Okay, so I thought that you might want to know her. Now, she too, with all of these credentials, have a hard time actually being hired. In fact, they don't even want to hire her for free. It gets so bad that the only way she gets her clerkship is that her professor at Columbia says he will refuse to send any additional students to the bench until they hire her. And that was the way that she began her journey. So then she becomes a law professor. But I love RBG because she kind of gets, irritated with the law and all of this discrimination. She goes to Sweden and actually writes a Swedish civil procedure book because she just cannot take the discrimination. She girds up and comes back, and of course becomes the first tenured woman at Columbia, right? We back to our first. She's elevated to the DC Court of Appeals, and the rest is history. So I wanted to talk to you a little bit about things she did, but I want to make sure, again, I'm quoting actual cases. Okay, yes, sir. So that's the time she's on the bench. No, that's not right, is it? So you caught that, yeah. So when was she on the bench till? Yeah. So yes, 93 until she actually died, unfortunately, which was 2020 because she was replaced by Amy Coney Barrett. So thank you. I do apologize, but I'm not going to tell you won't find another mistake because I am human. But I do thank you for correcting me. Okay, so I wanted to reach to you though, how after she was elevated, RBG did go on to write the dissent for a female worker being paid significantly less than males with her same qualifications. She was sued under Title VII, but was denied relief under a statute of limitations issue. She later helped Obama, first legislation to right this wrong. This is why I love her, right? And so she creates the Fair Pay Act. You remember that, ladies? Yeah. So that has her name written all over it. Now, we are going to go, and I hope my dates line up because you guys are good. I can't say that you're not. All right, who are we looking at next? Who's our next justice? Sotomayor, right? So this particular case is interesting because she wanted to talk about how when individuals are arrested and they actually receive Miranda warnings, how silence does not equal, right, that they're acquiescent. So Miranda rules and protections have always required more in order to have a valid waiver of such rights. And so that's her quote. She actually is pretty interesting herself. She was born in the Bronx. And as she's in the Bronx, her dad dies when she's 9. Now, she is living in a housing project, but it's a coveted housing project. You ever heard of a coveted? No? It's one of those things where it's new, has all the bells and whistles, and people want to live there, at least initially, right? So she was there. Her mom actually raised her and her siblings, and she was able to give them a Catholic education by herself, working as a nurse. So she goes on and she earns her way. I love how they say that, into Princeton. She actually gets a scholarship. When she's there, she alleges that there's discrimination against Puerto Ricans. And she sort of starts to make this her lifelong journey. She starts to talk about and write dissertations and theses around this whole discriminatory practice for Puerto Ricans. This earns her actually getting into Yale, and then her career starts. So Justice Sotomayor is feisty. She is known, this is her fun fact, to rip attorneys apart who are not prepared. But she is very kind to individuals who don't have attorneys and attorneys who are really prepared. That's just the way she is. And so actually parties love to see her because they like to be prepared, right? She does that. So in 79, she becomes an assistant DA. In 84, she's in private practice. She goes on to be elevated to the Court of Appeals of the Second Circuit, I'm sorry. And then she does one of the most monumental cases known to man and the court, and that's the Citizens case. So I wanted to read a little bit of this, but before I say that, she is known to be the first Latina. That's not my words. That's others who follow her in her words. But she's a first of many things, right? So she's the first to actually begin her career where she comes out firing questions. Usually justices kind of sit quiet. They learn from other justices, not Justice Sotomayor. She came right off the bench doing what she did best. Okay, so her first case is where she dissented from the majority, which held in favor of the rights of corporations in campaign finance. And this was really about a First Amendment right of corporations during political campaigns, in which the court ultimately held that corporations are protected and have legal personhood for such campaigns. So she goes on to do many things, but I think the one thing that Justice Sotomayor does is she dissents gracefully. She's very meticulous about putting in her dissent how attorneys in the future may use what she's writing to have winning cases later. She does not just have this sort of tunnel vision or right now. She looks ahead. And so that is what Sotomayor does best. All right, you guys are rolling with me. This is who? Kagan, authoring a 5-4 majority opinion, holding that a reckless offense cannot qualify as a violent felony if it only requires a mens rea of recklessness. So the whole deal here is that if we're going to say that something is a violent felony, it should actually match that sort of criminal intent, and that's what mens rea is. But here they say that it's a lesser culpability. And so Justice Kagan clearly and accurately said that this cannot be the case, that we needed to redefine what a violent felony is. So Justice Kagan actually is hailed as Mrs. Pop Culture. The court kind of holds her as this kind of young, exciting, interesting, technology-involved justice because of her connection to technology and other things that she did in her career. You can see that she earned her way into Princeton, and after she graduated, she even became a fellow in Oxford. And then she graduated Harvard Law. But Justice Kagan actually clerked for Thurgood Marshall, which then sort of start to change how she viewed things, I think, in a way. It provided sort of a foundation where she could see things a little bit different. And the reason what I'm saying is that we're talking about diversity, right? But remember, I said it's not just diversity of gender, not just diversity of, right? Not just diversity of political party, but it's diversity of thought too. So it's really important that you have various aspects of the country represented on the court. So she goes on, and as this young woman reported, she has no judicial experience. But here's what she does have, which I think you'll be impressed with. University of Chicago law professor. Then she goes on to become a Harvard professor. She is the first dean of the Harvard Law School. Do you see the year there? 2003 is when she started. Harvard was around since 1936. They had never had a woman. Also, she becomes the first Solicitor General. Should I tell you when Solicitor General started? 1790. Diversity, right? We're still on that diversity piece. And so she goes on to make it her mission to make sure representation is diverse. I'm going to skip her speaking on the the actual cases because I want to make sure we're going through and getting to where we need to for questions and so forth and discussion. All right. Anyone know who we're speaking of now? Okay. So I want whatever thought you came into this room with about Amy Coney Barrett, wipe it away. I was impressed as a lawyer when I saw this quote. Let me read the quote to you. While history looms large in this debate, I find the historical record more silent than supportive on the question whether the founding fathers, understood the First Amendment to require religious exemptions from generally applicable laws in at least some circumstances. Now you might say, she's only penned 8 opinions. I have to say that. She's only been on the bench since 20. But I think the fact is that most people would think she's against this, but these are her words. So this is what I mean by sometimes when you see a justice, you think they will rule or go one way, and then after they look at everything, they have a different thought. Okay, Amy Coney Barrett, you might say she's homegrown. No, you're not gonna say that? Okay, she's from your area. She's homegrown whether you want her or not. That's the case. She represents Illinois. Okay, bad background is she was born in 72 in New Orleans, Louisiana. She went to Rhodes College, went on to get her JD at Notre Dame Law School. She later returns as a professor, right? She clerks for Justice Scalia, and she goes into private practice. Her story is sort of interesting because she then starts to elevate within the courts, but she spends a great deal of time sort of honing in her constitutional law expertise. She was known for that, I must say, in her circles. So in 2017, she's elevated to the Seventh Circuit, and she wrote that one opinion you saw in Fulton. Again, there's not a lot out there on her because she's still new. All right. Now, perhaps the future woman of the Supreme Court of the United States. Maybe you're a little skeptical, but I hope what you will come away with before we get to this last part is recognizing that we need more than just one kind of diversity. If I cannot say anything else, I'll say that a million times. We need diversity in thought. We need diversity in geography. We need diversity in mindset. We need diversity in experiences. We need diversity in who has interactions with our justices. All of that comes with them when they are on the bench, whether we like it or not. So if we want someone to be on the bench who has sort of been involved with millions and millions of people, perhaps this may be your nominee. Stated simply, the primary takeaway from the past 250 years of recorded American history is that presidents are not kings. Now, I know we might feel differently about this quote, but I chose it for a reason. What was the whole purpose of us formulating the United States of America? We want a king and we want him now. So this sort of takes us back to this process. And this particular nominee says, dismissing the longstanding argument as a fiction and a proposition that cannot be squared with core constitutional values. She was known for that particular quote. Who am I talking about? I'm going to call her a probable, right? We have not had a vote. We have not even vetted her properly, if we're going to be honest. So I'm going to call her probable. Judge Katanji Brown Jackson. She's 1972, reared in Miami-Dade. She actually was born in DC. And she she went to Harvard undergrad and Harvard Law. Her sort of path is interesting. So she clerked for district judges first. Then she followed behind Justice Breyer, not just on the bench, but in almost every single thing that he was appointed. So Justice Breyer was on the United States Sentencing Commission, and that's not listed. In 2003, Judge Brown Jackson was on that commission. Judge Breyer became vice chair of that commission. In 2010, Judge Brown Jackson became vice chair. It is clear that whoever was looking at her has been looking at her for a while. And she would then replace Justice Breyer, right? So what we see is that there was not just kind of one-offs. These people are typically there and set up. So 2013 district judge for DC, 2021 district court of appeals, she was elevated, and now, of course, she was nominated February 2022. What I think you should take away from this is the diversity. Well, yeah, she will be the first African-American justice. We also had a first Latina justice. We also had a first woman justice. That is what we do. But I think the bigger picture is what other diversity does she bring? She was a single parent at one point. How many single parents do we have in the country? She actually was and will be the first federal public defender on the bench. How many people are involved in or are defenders in our country? We've never had a public defender on the bench. Does that surprise you? Yeah. Not only that, I think it's really important that you know that she was on the federal side, but that she was determined, not she was determined, because of course she couldn't nominate herself, but the last person who actually represented criminal defendants, do you know what justice that was on the bench? Thurgood Marshall. So we need diversity in someone who represents criminal defendants. It doesn't matter what your thought is. The law says that we should hear all sides. I say we should hear all sides. And if we have not had these voices at the proverbial Supreme Court table, we're missing out on that diversity. You agree? Okay. So, believe it or not, you guys look glossy-eyed. I always tell my students, look, you know what time you signed up for. When you came here, you knew it would be at 7. But we are at the end. We are at the end. Any questions? But before you go to questions, I wanted to share with you something that I have created at College of DuPage. It's Introduction to Restorative Practices. It provides that proverbial voice for others who are not necessarily there. When I talk about the diversity, this particular course is offered summer and fall, and it's a very short course, 5 weeks. But more than 46,000 jobs, 46,000 jobs actually require this skill set. Now, I don't know if you were aware of that, but in a lot of ways, people are now being elevated who receive this skill set. So it is my mission to increase the availability of the skill and to provide it. College of DuPage is so great at doing that at a rate that is affordable. When you have this credential, you actually can put it on your resume, and individuals are more than likely to then actually give you an interview. I'm not going to tell you you're getting hired. You need to learn the concepts and use them. But you understand what I'm saying. I don't think most individuals know that this skill set is now one that, and this isn't just in justice studies. This is in economics. This is in education. This is even in hospital staff. They've asked us to look at and help train. Because people do not know how to sit at the proverbial table and actually come to some sort of diverse compromise that is actually effective for all. Okay? So I'd like to tell you about that. Now, for real, questions. No, actually, we want to take you guys. You showed up. And to our chat, we can get ready to start those questions, Barry. But if we have any here, is that okay? Okay. Oh, that's lovely. Okay. Can we stop it? Okay, perfect. Let me go here because right? I don't think we've heard your voice. Ah, okay. Oh, I'm so glad you asked that. So what is the term restorative practices actually means? The term actually is not a new term, so I'm glad that you asked about it, but it's this concept or skill set where individuals who are involved in some sort of harm, in the case of justice, it's harm, come to the table and they actually bring their communities and they work through the situation. So most people think that that means that someone will not receive jail or prison time, which are two different things, right? Actually, those who are involved in restorative practices, there's an 85% satisfaction rate. I'm not sure if you know about what the court's rate is, but it's nowhere near there. Unfortunately, it may be like 25. But what happens is individuals are able to discuss. So I'll give you an example. A mother actually had her child murdered. Everybody tracking with me? The child was murdered. And, the child was murdered. They went through court. He received a life sentence. And the woman actually used restorative justice in that case to bring this individual to the table. Everybody was concerned because this mother was still very, 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 right, hurt and pain, but she had something she wanted to say. And guess what? Only her daughter's killer could give her the answer. Everybody tracking with me? So they come to the conference, they come together, and she asked him, where is her Bible? I should probably go back a second and say that the man that murdered her child was her child's husband. But he knew the Bible was something that was very special to her. She gets the Bible, and no, she doesn't forgive him. But it gave her an opportunity to get something that she could not get from the courts. Even placing this man behind bars for life did not take away or comfort her in the way that she needed. So it brings all of those voices to the table. Typically, it's going to be the victim or the person who has been harmed, anyone who they choose to bring with them as support. We call those communities of care, and the individual or the defendant, if you will, who caused the harm, their communities of care and a facilitator. So it's a process that the courts have found that when they run simultaneously with justice, actually comes out better. This is done also in areas like education, restorative practices in education. It's also done in areas with employment. I run circles sometime at my own job, depending on what the issue is, because sometimes we just cannot hear one another. And so we have to take a pause. And all the time, it's not good to bring everyone together, but this is a lot of work. Please do not think that this is easy. You run conferences with each side before. You ask, what do you want? What is it that you're looking for? And you only bring people together if you think you can fulfill it, because you don't want to cause more trauma and harm. Does it make sense? Okay. Yes. So the state Supreme Court actually requires, and I'm glad you said that, because I have something for you. Does the state Supreme Court work the same way? And I'm not sure if I'll be able to share this, But rather than just give the answer, I like people to find it. The state Supreme Court, you are nominated. So let's do Illinois. Would that suffice? Okay. All right. There we go. Let's see if we can get it going. We'll try this. A better thing, here we go. Now, you notice when you said state Supreme Court, there's more than one. So there could be the Supreme Court, there could be the appellate court. I just chose the Supreme Court. When you go to the Supreme Court of Illinois, though, it lists the actual qualifications and the process. So here you are, where you will see, it's not moving. Can you see this? You first have to have vacancies. We also have districts, and then they're elevated. And here are the qualifications and the process. Let's go now to the actual Illinois Supreme Court. But one thing I think that you should be aware of, that within any court, the vetting process is very much the same, right? You're going to be hammered with questions. You are going to receive a recommendation. Justice Katanji Brown actually received the Fraternal Order of Police's recommendation. I don't know if you know that. But here we are. And so if you go here, you can look at it ad nauseum. I will not get into the specifics because depending on if you want a state Supreme or an Illinois appellate court, it's going to be a different answer. But I did give you where you can find it. We good? Okay. This gentleman. You had your hand up. I'm a teacher, I remember. Oh. I didn't hear it. I will repeat it. Say it one more time. Introduction to Restorative Practices, the course. What forces? Okay, that process is actually voluntary. We never want to use the word force. But what people are finding out is that the processes that are in place are no longer holding the satisfaction. So people actually want to go through this process. This woman I spoke about, she had to request an appearance in a conference with the murderer. No one comes to her and says that. She requested that. But again, that's just injustice. We have that process in education, in employment, healthcare, economics. It's everywhere now. And the reason is, believe it or not, people need mediators. They need facilitators. They need people to help them compromise in where they're at. And that provides more satisfaction than forcing or screaming or yelling at someone. And that's why 40,000+ jobs are now looking at it. That makes sense? Okay. You had a question? Because they're tough. He said because they're tough. They're from that area. I think that, tough or not, what I saw in every woman, and I say this really humbly, is the tenacity and the determination to never quit, right? Ruth Bader Ginsburg, I didn't give you her fun fact. She worked out every single day in chambers with a trainer. Oh my good gravy, right? You start to see she never missed a hearing but one. And it was because she was in surgery. And after the surgery, she came right back. Who does that? Right? We get a splinter and we're out for 6 weeks. So whether it's their geographic diversity or just that sort of it to keep going, that's what I saw in the women. So I'm proud to be called a woman after that. Yeah. Anyone else Yes, sir. Ah, so I actually talked about this, right? We need more than diversity of thought, of race, of gender. We actually need diversity in law school. And I truly believe that. Now, some people may say, well, those are the best schools. Well, that's, questionable. Some schools teach theory, some schools teach practicum. In this instance, this is more of thinking areas. But I think as we start to see the court become more relatable and palatable and sort of interacting in our culture, you'll start to see some of that change. But you're exactly right. Harvard, Yale, Columbia, right? Princeton, you can name them. Stanford, it's a very tight-knit community. So the question was, why do we not see more diversity than Harvard? I hope my online audience got that. I'm so sorry. I'm gonna come here and then here, okay? Yes, ma'am. So when I first started teaching constitutional law, I would have my students create a chart. And the chart would say, name your justice, name the geographic area that they were elevated from, and their age. And each time I did that assignment, my students would say, they're too old to be on the bench. Why is it? You know what I mean? And I don't share that opinion, but I wanted them to know who is and what is the bench composed of. I do believe that justices should be honest. What I've seen to me is some people are holding the seat so that they can have a certain someone pick the certain someone and kind of control the court. I think that needs to stop. But I think in terms of whether or not there should be a term limit, actually, Chief John Roberts is taking up that very question. Believe it or not, he's thinking about it. Of course, he's only thinking about it now that he's been on the bench. He was 50 when he got on. So he'll have at least, right, 25, 30 years. Now he wants to take up the question. Better late than never, and after me is what he's saying, right? But I think ethically, we have to be realistic. However, I must say, there are a lot of people in other branches who exceed the age of the justices who are sharp. I will not name names, but you know them. Some of them are women, high positions in other branches, right? Taking lead. Diversity on every level. The more diverse we tend to get, the more that imbalance will start to balance out. Not just legally, morally, and humanly. Okay, whew, you're up. It's happening. Yes, I hope he didn't forget. Yes, sir. No, he had his hand up again. Yes, sir. I'm telling you, I can remember. I may be talking, but I can see. Anyone else? Oh, you're ready? I didn't hear you. I'm sorry. Changing the number of justices. Limit. Okay, so this is, some people like to, again, I'm going back to the United States Constitution. Is there a set number? No, right? So do I think there needs to be a limit? If there were a limit, it needs to be an odd limit, is what I would say. This goes kind of back to this pack the court scenario. If we are properly balancing, if we are providing geographic diversity and law school diversity, if we're providing great gender and race and economic, socioeconomic background, then we don't need to limit. We need to let them work. But if we're not going to work to actually do all of those things, then what will the limit do? You know what I mean? So you're hearing the same voices, and that's the thing that has to be different, I think. And that's my humble opinion. Yes, I love saying her name. Mm-hmm. Mm-hmm. Yeah. Yeah. I have to repeat what you say, so I'm gonna try and do it justice, but feel free to correct me. What this wonderful woman in the front is saying is that there clearly is an issue with individuals saying that they're against Harvard education, specifically for Judge Katanji Brown Jackson. Now they are. Yeah, because we need more diversity. But what I will say is this, and this is why I think it's important to point to the other pieces of diversity, right? Rome wasn't built in a day. So now we at least have a public defender coming on the bench, someone who's a single parent, someone who was educated. I believe either her mom and dad were teachers, or mom was a teacher and dad was an attorney. But she's coming from that sort of background where she understands, because they did not have a lot. It is not a background of privilege, but if it were, I want to be really clear. She has enough pieces of diversity that is going to change the voice of how we're doing even dissents. Because we only like to think of majority opinions that actually win, but you have to think of the court as something that's going to be long-term. And her voice will matter because she's setting forth different issues for later. That makes sense? Okay. I can't believe you guys can sit here and chat about the Constitution like me. I mean, I know why I do it, but I can't believe you guys like it. That's why you're here, right? And in person, yes. Oh, that has only happened one time. But yeah, there is a way to do it. We don't like to talk about it because we like to stay on the other side of that. But it happened early on in the court. And yes, it can occur. But it is not, obviously, it's not something that happens often. I think I should go to questions online. Do I have any? Do you believe Judge Katanji Brown Jackson will have the toughest confirmation hearing in history? Oh man, this is an interesting question for me, and I think a really good one, by the way. Tell my online community that. But here's what I will say. I think you have to think about it in steps. So remember, our first woman, Justice, did not come on the bench until 1981. Do you think her confirmation was difficult, her hearing? The first woman, Justice, did not come on the bench, right? Okay, so now our last woman, Justice, only took a month. So I don't know. Looks like we're sort of setting ourselves up to go fast. But what I do think is that because now we have Google, I can't believe I'm saying this, I'm getting older when I say we have Google, and everybody thinks they know and can find out everything. I think that you will hear some different terms. Now, I wish I had time to show you a clip of one of the previous confirmation hearings for Attorney General Merrick Garland, and the question he was asked about systemic racism and unconscious bias. What I think should happen is people should get educated before they go into the confirmation hearing, because they're not telling the American public the truth, and that's the truth. So she seems to already have been through a confirmation hearing. She received 5344, I think were her numbers. So we are watching, the world is watching how she gets confirmed this time. That's really what the legal scholars are saying. If she was good enough then, she should be good enough now, right? Yeah, so this is what I think is happening. And I do believe it will be difficult, but I don't think that I can tell you how difficult. I think we may see some things appear that we are not comfortable with, but I'm a type of person that I like to confront things head on. So bring it all out. so that she can get on the bench and do her job. Yes, the gentleman here asked, can you remove a justice on the bench? And I said, yes, one time. It's past my bedtime, so I'm blanking on the name, but I can tell you it's earlier in the court and I can find it for you. No. Yeah. Are you really putting me out there? Oh my goodness. Well, no, I really don't have a favorite. I don't. I'm completely unbiased. That's my answer, and I'm sticking with it. In case you don't know, I'm touching my collar, right? Right. And I think I like RBG for a few reasons. She was so little and yet so tough. And the fact that she never stopped going, I really connected with her family story, how she still placed family first. I don't know if you're aware of this, but she has a daughter-in-law who created a whole show. Her son is heavily engaged in music, and her daughter-in-law created a tribute to her. And that actually was performed at College of DuPage, and we had a chance to interact with her family, and it was wonderful. So seeing that kind of legacy and people wanting to help people and yet pushing past whatever really sort of endeared me to her. But no bias. 2 or 3, right? Yeah. Anyone else? No? Nothing? You guys have been an amazing, amazing audience. Thank you.